Defendant seeks as a sanction the disqualification of the state's two lead prosecutors. Because this does not appear to the court to have been a purposeful violation. What? But rather a negligent overlooking of the impeachment value of Lil Woody's in-chamber statement, the court does not order their disqualification. Judge Whitaker talked about in her denial of that last motion we looked into that was trying to disqualify lawyers Love and Hilton, that Mr. Stillwell actually had a motion that he wanted a fair and constitutional trial. Now we're going to see what her ruling was on that, and we're going to read through it and see some of the reasoning behind why she feels that way. All right. Shannon Stillwell, aka SB, aka Mr. Max Shart. And this is from Judge Whitaker. She says an order on defendant Stillwell's renewed motion for a fair and constitutional trial. All right, y'all check this out. Defendant Stillwell raises numerous assertions of error, impropriety, prosecutorial misconduct, and judicial partiality. Y'all see, I got it that time. I've been practicing, which he asserts have resulted in a denial of his constitutional right to due process and fair trial. The pertinent determination is whether such events, if they occurred as alleged, warrant a mistrial with prejudice, dismissal of the indictment with prejudice, which would have the same effect, or disqualification of the prosecutors. Claim 1. We know the claims, but we'll read through them pretty quickly. A plague of discovery violations, missing police reports, and Brady violations. Discovery is being addressed. We went through that this week. The court has ordered the state to timely produce all discovery and undertake a concerted effort to secure and provide all police reports, including asking current APD personnel with specificity to search for and produce reports on this case. And I think that's due next or midweek is what Judge Whitaker said. Okay. And then as recently as the court proceedings on Friday, August 1st, the court confirmed that the state's understanding that Brady obligations include the disclosure of material impeachment items and reminded the state of its continuing obligations under Brady. All right. Claim 2, prosecutorial failure to follow the court's orders, making of specious allegations against defense counsel and counsel for a witness, and lack of candor to the court. We all read from the transcripts on June 7th that they were talking some mash. Any past failure of the prosecutors to follow orders of the court is a matter of record. Aside from the broad assertion of a denial of defendants' rights to due process and a fair trial, no specifics establishing this assertion and no claim of refuting legal error is alleged. Okay, so it looks like she's going to move on from that one. So we'll keep it going too. Basically, she's saying the past is the past. Any specious allegations against defense counsel for a witness, or a lack of candor with the court at minimum is extremely unfortunate. She said, I'm sorry y'all got your feelings hurt. Claim 3, improper evidentiary rulings by Judge Glanville. A defendant is entitled to a fair trial, but not a perfect one, for there are no perfect trials. The people's versus the state. Evidentiary error, which involves mistakes under Georgia's procedural rules and evidence law rather than any constitutional violation, can be addressed in post-trial review. Okay, so we just got to wait. Lord have mercy. Claim number 4, mistreatment of defendants and their counsel by Judge Glanville. Aside from a blatant assertion, the motion does not detail any alleged mistreatment of defendants. We got whole YouTube videos we could point to if you need to see them, Judge Whitaker. Come on now. The alleged mistreatment of the defense counsel detailed in paragraph 9, A, E, and H is not alleged to have occurred in front of a jury and even accepted at face value, would not raise the level of violation of defendant's due process or fair trial rights. So he didn't do it in front of the jury, even though he called Brian Steele unprepared and unprofessional. Still not enough to be an issue is what she's saying. Claim 5, improprieties in and illegality, of the June 7, 2024 ex parte conference. In open court on June 7, 2024, the prosecution requested an ex parte conference with the court. June 7th, 2024 transcript, page 94. The defense was therefore on notice of this request. The defense also knew that the request was not to secure immunity for Lil Woody, as the immunity order had been signed in open court earlier in the same day's proceedings. Even assuming the right to be present for this June 7, 2024 conference, no one on the defense team objected to the request or sought more information about, thereby waiving any right to be present for that conference, which I don't remember seeing them saying that they should have been present, but I could be wrong. I could have missed something. As for the topic of the ex parte conference, defendant assigns nefarious intent to prosecutors Love and Hilton's representations about their interactions with Lil Woody's main counsel, John Melnick. The court at this point declines the invitation to view their representations, but refers the prosecutors to its footnote 1 herein. Yeah, but they were also saying some stuff about Kayla too. So we'll just go down through these. Claim 6, illegality of the June 10th, 2024 ex parte meeting. We know what that was about. And then we had, oh man, he tells the whole story here. And we already know pretty much why Judge Whitaker said the ex parte meeting wasn't a big deal. And she basically is reviewing that and going through that again. So let's go back to this last one. The defense knows of this statement and indeed of all what occurred during the June 10th, 2024 ex parte meeting. The contents of the meeting were ultimately revealed during the course of trial and in time for defense to utilize it. So failure to produce such or suppression of this information does not technically amount to a Brady violation. And they're saying Kayla didn't really show or give her anything that would say, yeah, this is information that the defense should have been made aware of. But the fact that a violation of a defendant counsel's rights has been asserted does not, under these circumstances, provide cause for celebration. All right. What it does provide is cause for sober reflection and examination of processes, or processes, if you prefer, procedures and approaches that permitted this likely inadvertent but nonetheless serious Brady lapse to occur. Defendant seeks as a sanction the disqualification of the state's 2 lead prosecutors. Because this does not appear to the court to have been a purposeful violation. What? But rather a negligent overlooking of the impeachment value of Lil Woody's in-chamber statement, the court does not order their disqualification. What is going on, man? Judge Whitaker, what happened? So because, how is it not purposeful? Everything about this was purposeful. And you even had Judge Glanville over there as a hype man, or Miss Hilton over there as a hype man, as Glanville's explaining to Woody what was going to happen to him, what everything meant. She would say, yeah, that part. Tell him. They're getting so much grace. It's absolutely insane. At the same time, the court is cognizant that defendant's liberty, as well as the liberty of his co-defendants at this trial, is at stake. That the prosecutors involved are knowledgeable and experienced, and that this is not the first allegation of prosecutorial misconduct in this case. So if you know that, then get them up out of here. The court therefore orders, as a remedial measure, that the entire prosecution team working this trial, submit to training on Brady and other professional obligations of a prosecutor. I don't understand these motions. How is the judge going to say they did all of this and messed it up and it wasn't a purposeful violation, it was just negligence? So what she's going to do is she's going to send them to training. Wow. Thank you, Judge Whitaker. Seems to be fair. Prosecuting Attorneys Council of Georgia. Oh, I'm sorry. Let me read that again. The training will consist of a video replay of training on this topics previously presented by the Prosecuting Attorneys Council of Georgia. I'm sure it'll make a difference. The court will provide the video and the viewing will occur under the direction of the court. So ordered this the 8th day of July, or the 8th day of August 2024. So Judge Whitaker, they're basically going to the principal's office and they got to watch a video. They have to stay after class and watch a training on Brady. Wow. So because of all of that, this motion is denied. Y'all have to let me know what you think in the comments. Are we losing Judge Whitaker? I'm kind of sad. I thought she was going to be solid. Maybe she still is. Maybe she's just doing her job, and we'll see what's going to happen in the next couple of days. Y'all let me know if she made the right decision.